1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်446 Union of Burma ဦးလေးစိန် Applicant vs Mountain AUNG Respondent ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision Before ဦးကျော်ဆန်းဦး Judge Union of Burma ဦးလေးစိန် Applicant vs Mountain AUNG Respondent Code of Criminal Procedure Section 28 Offense under Section 338 Penal Code whether the court is entitled to omit framing of charge under more serious offense to acquire jurisdiction. Hell, Section 28 of the Code of Criminal Procedure say, subject to the provisions of the code, any offense under the Penal Code may be tried by the court, by which such offense is shown in the 8th column of the second schedule of the Code of Criminal Procedure to be triable, and this schedule show an offense under Section 338 of the Penal Code is triable by the Court of Session or the magistrate of the first class. When he became aware of the fact that Ule Singh had received a grievous hurt and the case came under Section 338 of the Penal Code, he should at least have referred the case under Section 346 of the Code of Criminal Procedure to the district magistrate with a brief report and stay the proceeding. The court is certainly not entitled to omit framing the charge under the most serious offense in order to acquire jurisdiction, and if it frames a less serious charge instead of the most serious one through a misappreciation of the evidence, it failed to exercise a proper discretion in the matter. The State vs. AUNG ILR 24 Mat 675 Dawson and 1 vs. the State ILR 2 Ran 455 Ainchadula Aganda and others vs. the State ILR 1944 1 Kill 280 refer to Ujogang Government Advocate for the applicant, Udemang for the respondent, Ujosan Judge in Criminal Regular Trial numbered 134 of 1965 of the Township Magistrate of Yinanchang, Unai Wing, who is a magistrate of the second class. The respondent was sent up by the police under Section 338 of the Penal Code for causing grievous hurt to Ule Singh, plaintiff witness to, by rash or negligent driving of the jeep, an offense triable by a magistrate of the first class on the first report lodged by MAUNG, plaintiff witness 1, though it was opened originally under Section 337 of the Penal Code for causing hurt to the said Ule Singh by rash or negligent driving, an offense triable by a second-class magistrate. After hearing the witnesses for the prosecution, the magistrate Unai Wing charged the respondent under Section 337 of the Penal Code in spite of the evidence of the medical officer, Dr. Sotin, that the bone of Ule Sing's right middle finger was fractured and dislocated. He also received other injuries under the 7th clause of Section 320 of the Penal Code. Fracture or dislocation of a bone is designated as grievous and therefore the respondent should have been charged under Section 338 of the Penal Code, as trial begins only after the framing of the charge. The township magistrate Wu Nai-win, being a magistrate of the 2nd class, could not have proceeded with the trial anymore. If the respondent was charged under Section 338 of the Penal Code, he proceeded to hear the defense and finally acquitted the respondent of the charge under Section 337 of the Penal Code. The Additional District Magistrate of Magui has now applied in revision to set aside the acquittal order and to direct a retrial by the 3rd Additional Magistrate of Yanchang, who is said to be a competent magistrate to try the case. There is no doubt that the township magistrate Wu Nai-win was empowered to try the offense under Section 337 of the Penal Code. He did not act beyond his jurisdiction, and therefore the proceedings are not void under Section 530b of the Code of Criminal Procedure. The words not being empowered by law in the section are significant, quoting the bench decision in the State vs. AUNG, which is the leading case on the point, with approval from Judge in Dawson and Wen vs. the State, to observe. Where the first disclose an offense within the jurisdiction of the magistrate, it seems to us a complete fallacy to say he is not empowered by law to try the person charged for the offense which is within his jurisdiction, because the first disclose a more serious offense which is beyond his jurisdiction. He is expressly so empowered. Whether in so doing he adopts a proper course is another question. No doubt it is improper on the part of a magistrate to intentionally ignore circumstances of aggravation which show that an offense beyond his jurisdiction was in fact committed. The question whether the magistrate has or has not entirely overlooked the circumstances would be one of fact. It will therefore appear that whether or not the chief court should interfere would depend upon whether the magistrate had deliberately overlooked the aggravating fact with a view to securing for himself jurisdiction over the offense. In the instant case, the medical evidence is so clear that no magistrate could have easily overlooked the fact that Ule Singh had received a grievous hurt. I think there is ground for believing that the magistrate Wu Nai-win clashed that jurisdiction. There can be no doubt in the present case that the proceedings were improper, in spite of the medical evidence which he himself had recorded. He refused to admit that it was a case of grievous hurt. If this were a slip, I should say it was a serious slip in a matter of law causing a miscarriage of justice. Section 28 of the Code of Criminal Procedure say, subject to the provisions of the Code, any offense under the Penal Code may be tried by the court by which such offense is shown in the 8th column of the second schedule of the Code of Criminal Procedure to be triable, and this schedule shows an offense under Section 338 of the Penal Code is triable by the Court of Session or the magistrate of the first class. When he became aware of the fact that Ule Sein had received a grievous hurt and the case came under Section 338 of the Penal Code, he should at least have referred the case under Section 346 of the Code of Criminal Procedure to the district magistrate with a brief report and state the proceeding. Presumably, a magistrate does not overlook the facts which he records unless he deliberately does so. The court is certainly not entitled to omit framing the charge under the most serious offense in order to acquire jurisdiction, and if it frames a less serious charge instead of the most serious one, through a misappreciation of the evidence, it failed to exercise a proper discretion in the matter. Aintadula Aganda and others vs. the State 3. In this case, retrial was ordered. For the above reason, I set aside the order of acquittal and order the respondent accused to be retried by any magistrate of competent jurisdiction who has not been previously seat of the case as directed by the district magistrate of Magui.